This bill.
I call David Clendon, 5-minute call.
Thank you, Mr. Speaker. This is an important piece of legislation. The family court plays an important part in our judicial system. It plays an important social role in New Zealand. It is a more than 30-year-old institution, and so it's entirely appropriate we should have a review of its functioning, to acknowledge its shortcomings and to seek better outcomes for those who are obliged to seek out its services. We can modernise, yes, that's a good word, and a key focus, a word that keeps popping up in this bill is accessibility. It's important that we have access to the court processes, but it's more important that people have access to justice, that people who are vulnerable have access to the protection of the state to which they are entitled, that people's well-being is protected. And access in that larger sense is something that perhaps is lacking in this bill, and one of the reasons we are unable to support it in its current form. It's proposed that the court and its processes are not sufficiently focused. That's a fair criticism. The fact that some of the processes are poor. Equally, these are reasonable criticisms and those we can take on board and seek good solutions for. But sadly, Mr. Goff, in his far from hysterical contribution, made the key point that the primary driver of this bill seems to be the focus on cost saving. We have this bald number thrown up, 84 million to 142 million, without an equivalent increase in applications. That's not a trivial sum of money, but there's not a lot of detail given us around that. I think if we drill into that, we'll find that perhaps the implication of this massive cost explosion is actually not particularly well warranted. But critically, it's almost an inevitable phenomenon of these sorts of cost-saving exercises, that you end up not saving money, but simply exporting cost, that you find that the money that's saved in one place will be imposed elsewhere. If we create behavioural dysfunction, social dysfunction, as a result of inadequate court provision of services, we'll relocate those costs elsewhere in the justice system, to the education system, to the welfare system. There will be no net saving in dollars, and there's likely to be considerable net increase in cost imposed on individuals, on women, on children, and indeed on fathers who are involved in these processes as well. So let's not imagine for a minute that cost saving in itself is a sufficient reason for the level of intervention and change that's been proposed here. We are told that this obligation to go to a dispute resolution process will reduce the something like 1,200 fewer cases coming to the court. 2,000 children will not of necessity be exposed to a court process, which is unlikely to be a happy process for them. But again, that's very superficial, those comments, and the point's already been well made by Mr. Little. There's a rather an odd logic at work here, and it's revealed in the RIS. The proposition that there's this flood of cases inappropriately coming to the court. We don't have the information. One of the key data sets that is missing is that we don't know what percentage of cases of separation actually come to the court. But we consume it's around that 10% based on evidence from the UK. So it's actually 12% of 10%. It's a very, very small proportion. And to suggest that, in fact, there is an overwhelming default to the court, that too few people are sorting out their own lives and their own business and the welfare of their own kids, is simply not sustained by the information. So we have had already submissions directly from some key organisations, Relationship Aotearoa, the Association of Councillors, the Law Commission, and it's unfortunate that some of those submissions have been some of those submitters have been accused of self-interest. The lawyers particularly, and we know that lawyers typically rate around there with politicians and used car salesmen in public perception. But I'd argue, sir, that people who go into family law, lawyers who specialise in family law, are very unlikely to be motivated by personal wealth. If you want to make a lot of money in legal profession, I suggest you'd not be very bright if you chose family law as your area of expertise. We have highly capable, very committed people in the legal fraternity working on this stuff, and I think it's a fairly cheap shot to suggest that the lawyers are simply feathering their own nests.
Sorry to interrupt the member.
Mr. Speaker.
I call Katrina Shanks.
Mr. Speaker, it's my pleasure to take a call in the family